Hello. Today we're going to talk about what happens if one of the beneficiaries called to inherit on a Spanish will does not sign the acceptance of inheritance deed. My name is Michael Davies. I'm a Spanish lawyer specialized in estate planning and probate, and we handle wills and inheritance work for expats all over Spain. And this is what I've been doing since 1996. Okay, so these are interesting cases and more frequent than what people would think. It's not very frequent, but we've had a few cases over the years, and it's a big problem. Okay, so the problem that we'd be facing is basically this: someone comes to see us and says, "Michael, I'm the beneficiary of this will." Shows me the will. There's 3 beneficiaries named. And one of my siblings or one of the beneficiaries, or my dad's ex-wife, or my dad's second wife, whatever, is just simply refusing to collaborate, or we can't even get hold of her, and she's one of the beneficiaries. What can we do? Okay, so the first thing is to see whether they're all beneficiaries, in which case it's a big problem. Or if somebody has been left what's called a legacy, in other words, an individual asset, which is taken out of the estate before the estate is distributed, if a legacy has been left and it's been left in a specific way, we have to see the wording of the will. Now, the will actually says, "I leave a legacy," and it gives the faculty for that legacy to be accepted by its beneficiary, even regardless of the rest of the estate. Sometimes wills are worded like that. We often do this with legacies, in which case at least that part can be dealt with. Let me give you an example. Maybe somebody leaves an apartment as a legacy to a specific child with whom he gets on very well. And then he says, "I'll leave everything else that I've got in Spain in 3 equal shares." Well, if that legacy of that property has been left with says on the will, with the faculty of the beneficiary to take over the asset regardless of the inheritance, then we can do a partial acceptance of the inheritance, and at least that person can start making use of the property or sell it or do whatever he wants to do. But if we've basically got an inheritance in which there's 5 beneficiaries named and 20% shares, or whatever distribution, and one of the people refuses to sign. And you may say, "Well, why on earth would someone not want to sign? That doesn't make any sense." Okay, well, let me give you some examples of situations that can happen. One, there may be a beneficiary who simply nobody knows where he is, because he's left years ago. Nobody can find him. Nobody knows where he is. That would be one of the possibilities. The second possibility is one of the beneficiaries is just very upset with the share that they've been left of the estate, and he himself has got money, and he basically just wants to cause pain to the rest of the beneficiaries. Or he could be using it as a negotiation tactic. We've been through this exact situation in the past, and this would be the case of a couple of brothers. One is very wealthy in his own right, the other one's not. The wealthy one refuses to sign the inheritance, and with a view of pushing his brother into accepting to sell out his part of the estate for a lower amount. Unfair, yes, but it happens. It can happen. What other situations could there be? Well, second marriages. Dad remarried. The kids have been left as joint beneficiaries or partial beneficiaries together with the second wife. The children are very upset. Just one of them refuses to sign, and we've got the problem. Okay. People don't actually realize how complicated this can get. There is an institution in Spanish law, and people immediately read about this on the internet, and you think, "Oh, well, that is the solution," because it seems a logical sort of a solution. Basically, in Spain we have a figure of a person called contador partidor dativo. There's no exact translation in English, but let's say he's like a special executor, okay? So what happens is I've got two children, one of them wants to accept, and the other one we don't know where he is. So we go to the Spanish notary, and the notary says, okay, there's only two solutions. Go to court, and going to court for the judge to award, to distribute the estate is a long and costly procedure in Spain. So we had to try and avoid it at all costs. So what other option has the notary got? Because only basically an inheritance in Spain, what the law says is that it can only be assigned by a judge's order or by a notary with the agreement of all the beneficiaries signing the acceptance deed. That's the general rule. So the notary can give us a second option. And the option is he can say, I will name contador partidor dativo. Okay, and he's got a list of the ones that have got this qualification and that can basically do this work. They're sort of executors, accountants. So he can name that person to take the position and defend the interests of the person that is not present. Okay, so he gives him the job. The contador partidor dativo is very expensive. Their fees are regulated, but they are very high. And obviously, on a large estate, they will be an amount to be considered. So he jumps into action, and the first thing he has to do is, with the collaboration of the notary, make the communication to the missing person of what is going to happen. Okay, and this is where we immediately hit the first problem, because he may communicate to this other person and they don't respond, they don't collaborate, they receive what's called a burofax, certified letter, a telegram, and they just refuse. Or we send what's called a writ via a notary, but we can't do, of course, he's in a foreign country. Problems start with the notification. Now, very little has to go wrong on one of these procedures for the notary to simply say, that's the end of this file, it can't be done, and therefore off you go to the court. So what's going to happen with this contador partidor dativo is that he starts his work. If there's any doubt whatsoever, he tells the notary that it can't be done. Okay, and the main problem you're going to have straight away, if there are foreigners involved and they're in other countries, is the notification. From experience, I can tell you it hardly ever works. Okay, so what will happen then is, if it's not, the notification has not been done in a way which makes the contador partidor dativo, more importantly, the notary, happy, the notary will just close the file. He'll have initiated a procedure with the contador partidor dativo, and he will close it, which you can do at any time. Close it and say, no, you've got to go to court. So that will basically, the naming of the contador partidor dativo will unfortunately lead to a lot of expense and a lot of wasted time, because almost for certain at the end, the notary is going to send everyone off to court. Yes, have a word with the lawyer that's done these things before, speak to us about it, but unless really everything is very, very clear, and this other beneficiary is going to respond to the writ, etc., which of course he won't do if he doesn't want to sign, it's all going to end up in court. So at the end, yes, it sounds very practical, it sounds very logical. Well, I've read on the internet that I can get a contador partidor dativo, and that is the procedure, we do it via the notary. Yes, but in practice, it probably won't work. Okay, so what does it leave us with if we're in this situation? Well, there's only two ways possible to deal with this. One is to reach an agreement with the rebel beneficiary, or we have to go to court. Okay, so in the past, we've always managed to resolve these things in an amicable way. It's a question of trying to find out what it is, what the problem is with the rebel beneficiary, why they won't accept. I mean, sometimes it's worth Sometimes it's like personal items that they're not happy with. There's a personal grievance, so maybe we can reach a settlement on that. Maybe one of the beneficiaries is just very unhappy because he considers that he's been given a really unfair deal by his father or mother. And sometimes we may even recommend, let's try and reconciliate this. And hey, if maybe the other beneficiaries have to maybe give him a little bit extra from what was being left to them, it may be worthwhile. It's a question of doing the number crunching, the court case versus the settlement. Okay. If somebody has simply disappeared, well, at the end of the day, maybe via Facebook, some of the different ways everyone can try and find people. So in a nutshell, if you've been called as a beneficiary and one of the other beneficiaries is not willing to go and sign the acceptance of inheritance with you, it is a problem, okay? And that the solution of the contador partidor dativo has to be looked into carefully by somebody that has done this before, because it's very likely that it would end up being a waste of money and time. And then it'll probably leave us, that has to be looked into just in case. And then we go on to the real two options, which is the court case or some kind of arrangement that makes everyone happy enough to go and sign the acceptance of inheritance in front of the notary. The other thing is also if one of the rebel beneficiary is doing it as a way to force the other beneficiaries into giving him more than he deserves, as in other words, basically holding the other beneficiaries to ransom. Sometimes the solution is to play around with, maybe we are prepared to go to court and you will end up paying the court costs because you are the one that's being unreasonable. And at the same time, carrots and sticks, see whether there's something that can make everyone happy. I hope this made sense to you all. At the end of the day, what I always think is that sometimes these problems can be thought about. Sometimes they're completely problems that appear out of the blue and nobody expected. But sometimes when the testator is making his will, he does need to think about, if he's got that son that hates his other brother and, they've never got on well, or he's got one son that's very, very distant and he's not going to be, maybe you should consider not naming him on the will. Because if you do, if at the end of the day he doesn't collaborate, it's going to cause a problem for everyone. Those of you that know us will have heard us say many times that if you're making you're dealing with your estate in Spain and you're going through what you want to do, leaving a very small participation to Auntie Mary, who we've never seen for a long, long time. And, maybe you leave, 45%, and then the last 10% I'll leave to, I don't know, someone that I haven't seen a long time. That can end up being a big mistake because it can mess up the estate for everybody else. So if you enjoyed the video, please hit the subscribe button for other content like this, and I'll see you another day. Thank you.